Someone make it make sense.
Probably a couple.
Hello, squirrel friends of the world. How are y'all doing today? Shout out to Iowa Backyard Cam. So y'all, I attempted to do this last night, and actually I already had a stream set up for today, as in not this stream, but a different stream for the next batch of Motions in Limine that undoubtedly will appear. And I accidentally went live on that one, but it was private because I didn't know when we were going to be having it, because I didn't know when the documents were going to come out. And so I didn't realize that until like 40 minutes in. So then I was like, oh, so no one can see this. So anyway, change of plans. So we're doing this now. Meg P needs an appetizer. Not now, Meg P, not now. Shout out to you guys who are here. And I'm sorry that I was in the wrong stream. And then we ended up doing BK anyway, which was, it ended up working out just fine. Just fine. So first off, we're looking at the docket here. This is from yesterday. So of what is here. So protective order. Okay, fine. So defendant's motion in limine to present demonstrative exhibit based on Christina Hanley's testimony. We have that one already. Defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad care. So that's all that. We have that one as well. That's dealing with Aruba. Defendant's motion to impound portions of defendant's motion in limine to exclude certain witnesses before and after testimony. We have that one. Affidavit of Miss Little. I don't have that one yet. Defendant's motion in limine to exclude certain witnesses before and after testimony. We have that one. Defendant's motion in limine to exclude. Okay, that's like the same thing, but it's redacted. Defendant's motion in limine for view, like a jury view. Don't have that one yet. Defendant's motion in limine to prohibit testimony regarding funds paid to experts for purposes of voir dire. Have that one. And then it continues on. Defendant's motion for attorney conducted panel voir dire. Don't have that one yet. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they take the stand. Have that one. Defendant's motion to impound. Defendant's motion in limine to exclude. This is a different one. So this is regarding harassment of witnesses. I don't doubt we'll be able to get that one if it's impounded. Don't have the affidavit. And then there it is again with the impounded one. And then defendant's motion in limine to exclude serum, blood out, all this with the blood. Okay, that's at the bottom there. Don't have that one yet. Again, we're waiting for these to all become available. I think some people have been able to find some of these. I haven't been able to find yet. I don't know where they're finding them, but it's okay because we've got a ton. We have like, I think 32 pages I've got of these documents. So here we go. And it's no small task. You guys have heard me talk about to get these. So yeah. So let's get started. Let's get it going here. So, make sure I've got my audio settings normal here. Cool. Okay. So first one's first here. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they have taken the stand. Now comes Miss Reed and respectfully, oh, DSN, happy to see you, my friend. Respectfully moves this honorable court to issue an order prohibiting the Commonwealth and its agents, including but not limited to the prosecution, law enforcement, and victim witness advocates, from speaking with or having any contact with any witnesses once the witness has taken the stand. During Ms. Reed's first trial, the defense learned that the Commonwealth was having improper conversations with witnesses while they were in the middle of their testimony. For example, on cross-examination, Brian Albert indicated that he had spoken with A.D. Lolly, aka the Lolly Bird. Where is he? Where is he? Here he is. Over the lunch hour while the court was in recess during the middle of his testimony. When asked what they had discussed, he initially denied speaking about the substance of his testimony, but then later admitted that A.D. Lolly had discussed some of the topics he wanted to ask him on redirect. Quote, he maybe mentioned one thing he may ask me, just he was going to ask about what happened at the house in the morning. Obviously, isn't that like, that's the point, right? You know, some of the questions on redirect, that's all, end quote. Now that's a dumbass answer because, like, again, that's the point of you being there. As grounds for this motion, Ms. Reed states that the court has discretion to prohibit communication between witnesses and attorneys or third parties. And therein lies the problem, right? The court has discretion. So, you know, Argument. And I will say, let me just say real quick, as far as Judge Bev goes, I was pleasantly surprised with the most recent ruling on regarding the sanctions and whatnot. We covered that. It was actually reasonable. However, to that end, I don't think it was her being reasonable so much as her wanting to get to that April 1st trial date. April 1st or bust. That's Judge Bev's motto, in my opinion. Okay, so in order to preserve, that's not a word. In order to preserve the truth-seeking function of the trial, Jesus Christ, the court should prohibit our agents of the Commonwealth from communicating with any witness once the witness has taken the stand. This is a particular concern during a recess or lunch break in which there is virtual certainty that any conversation between the witnesses and the lawyer would relate to the ongoing testimony. For similar reasons, the Massachusetts Rules of Criminal Procedure permits a judge to exclude a witness other than the criminal defendant from the courtroom when they are not testifying. The same danger that a witness's testimony may be molded by conversations with others is present when the witness speaks with the prosecution or other agents of the Commonwealth during breaks in their testimony. Again, this seems like common sense, goes without saying, but it already happened during the first trial. Now, I didn't cover anything pre-trial for that, as you guys probably know. I'm not sure if they had also filed a similar motion ahead of time last year and if it was denied or whatever. But either way, even though this seems very reasonable, who knows what Judge Bev will do, right? So there you go. Flashman says, I'm glad you're passing the message along. Thank you for that. Thank you for that. Okay, next up. All right. This is the Aruba. Defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. And that's the thing, is like prior bad character, I mean, that's debatable, right? When it comes to this Aruba incident, which is just dumb. I mean, honestly, it should be, okay, Rule 403, right? You know, that deals with a lot of things, including, you know, waste of time. There's other things that also pertain to the freaking Aruba testimony, but I think the biggest one of all, waste of time. Waste of, like, just complete waste of time. That was the dumbest thing. Absolute dumbest thing. All right. Now comes the defendant, removes this court in limine to exclude any references to the irrelevant, inadmissible, and prejudicial events that purportedly transpired in Aruba on December 31st, 2021. As grounds for this motion, should the court find that the evidence is relevant, any potential probative value of the proffered evidence is outweighed by the substantial risk of unfair prejudice to Ms. Reed. We know the factual background at this juncture, methinks. The defense, let me zoom in a little bit more for you guys. The defense suspects that the Commonwealth will again, God. Remember when back in the day at the first hearing with Hank Brennan, when he was like, I'm going to appear down the witness list, I'm going to get rid of all the fluff, It seemed like it was obvious that Aruba was out. Like first things, like Aruba's out, right? No more Aruba. But apparently that's not so, or we wouldn't be reading this. The defense suspects that the Commonwealth will again seek to admit testimony regarding a completely irrelevant, agreed, verbal agreement between Miss Reed and a woman named Marietta Sullivan. God, I hated that. I hated this so much, which occurred in Aruba on December 31st, 2021, for the sole purpose of trying to assassinate Miss Reed's character in the eyes of the jury. At Miss Reed's first trial, every single witness unequivocally testified that there was no history of violence whatsoever in Miss Reed and Mr. O'Keefe's relationship, and that the two of them were in good spirits on the night of January 28th. Despite this, the Commonwealth repeatedly elicited inadmissible testimony regarding a verbal incident that occurred in Aruba 1 month prior. Speaking of Aruba and Flash Fan, right? Because he was in Aruba just recently. Between Miss Reed and a third party which had no logical relationship to the crimes charged. Yeah, well said. The Commonwealth has no reliable evidence to suggest that the Aruba incident had anything whatsoever to do with John O'Keefe's death a full month later on January 29th, 2022. Or that this remote and isolated incident was even a point of contention in Miss Reed and Mr. O'Keefe's relationship after that trip. That is hilarious. Before the barely honorable judge could. That's being very generous, DSN, in my opinion. Hey, okay, at the first trial, the Commonwealth called Laura and Marietta. Right, they brought two of them in. Insanity. Laura and Marietta Sullivan to testify about a highly inflammatory incident, which Miss Reed apparently got angry at another woman, not the decedent, because she purportedly believed that Mr. O'Keefe had kissed that woman. The Commonwealth intentionally admitted this prior bad acts and character evidence for no reason other than to sully Miss Reed's character in the hopes that the jury would indict her based on the fact that she was, in Marietta Sullivan's words, an asshole. At trial, Laura Sullivan admitted that she was not present during this verbal exchange, Jesus Christ, between Marietta and Miss Reed, so her testimony about the incident in Aruba is almost entirely comprised of inadmissible hearsay. Despite the court's limiting instructions about bad character and propensity evidence, the Commonwealth was permitted to elicit prejudicial testimony from Laura Sullivan that Mr. O'Keefe purportedly called Miss Reed crazy. Ouch, sick burn, right? Jesus Christ. And that he had insinuated he was unhappy in their relationship. Wow, that's some damning evidence. Not Marietta Sullivan's trial testimony was also extremely prejudicial to Miss Reed. You know, and the other thing too is when we heard from Ronnie the juror, did they ask? I feel like they must have asked him about Aruba, right? And I'm sure he must have said this was dumb. Do you guys remember specifically what he said? I mean, we watched both of those interviews. I just can't recall if Aruba came up because it was that dumb, right? It would have like not been a priority, maybe, hopefully. But I feel like if he was asked, he probably said, yeah, that was dumb. Let me know if you guys remember. Her retelling of the verbal dispute with Miss Reed was not probative of any material fact or element in the case, and it culminated with Marietta telling the jury decidedly that Miss Reed sucks. I mean, like teenagers, right? As set forth herein, this evidence must be excluded. Argument. The sisters Sullivan, exactly. Like Brother Nagel and Sister Nagel. Yep. The Aruba incident constitutes inadmissible prior bad acts, and character evidence and potential relevance is outweighed by the risk of unfair prejudice to the defendant. Motions in limine concerning the introduction or exclusion of purportedly relevant evidence are properly made and considered before and during trial in advance of the evidence being offered. The purpose of a motion in limine is to prevent irrelevant, inadmissible, or prejudicial matters from being admitted in evidence. And in granting such a motion, a judge has discretion similar to that which she has when deciding whether to admit or exclude evidence. Well, yeah, that's literally what the point of a motion in limine is. Are you going to admit or exclude certain evidence? It is a fundamental rule that the prosecution may not introduce evidence that a defendant has previously misbehaved, indictably or not, for the purpose of showing his bad character or propensity to commit the crime charged. And to that end, if it was, in this case, the propensity would be to accuse people of kissing other people, right? Which is not like, don't think that's actually illegal, right? You're allowed to do that. Although this type of evidence is sometimes admissible for other relevant purposes, such as to prove a common scheme, pattern of operation, absence of accident or mistake, identity, intent, or motive, these exceptions are not without limitation. And literally, that's exactly how in Murdoch, and the defense opened the door, first of all, but that's exactly how some of that other stuff came in. Speaking of which, we will be getting into that on our next Murdoch revisiting the trial. It'll be a big day. That was an awesome sojourn during the trial. The altercation in the lobby in Aruba and that woman who scheduled, right? And that there were like 40 people there. So bizarre. I was like, this is very odd. I mean, you guys probably heard me say it at the time when we were watching it, because the whole way that the whole thing got going was very odd. But it sounded to me like this was one of those things where she gets some sort of a percentage, like a cut, because there was some financial thing to it where it's like she invited people she didn't even like fucking know, which I thought was interesting. You know, where it's like it behooves you to just invite everybody and their mother, even if you don't want to go on a vacation with them. Like, sounds terrible to me. Similarly, although evidence of a hostile relationship between a defendant and his spouse may be admitted as relevant to a defendant's motive to kill the victim, such evidence should not be admitted if it relates to events which occurred at a time too remote from the killing. So that's one thing that, again, this will be in Judge Bebb's discretion. I don't know that she will find the timing of it too remote. I mean, one would hope that the relevancy would be enough, right? I don't know, but to me, the timing of it is not going to be the strongest argument here, because a month is not, I mean, in terms of remoteness, that's not that remote, right? But of course, it just depends on the case. And, you know, we see cases all the time where there's things that happen years prior that come in. So temporal remoteness is not an exercise in line drawing. Rather, a reviewing court focuses on the logical relationship between the prior bad act evidence and the crime charge, right? There is no logical relationship. So back to what I was just saying, the strong point there. Here, there's no such logical relationship. Yep. In order for evidence of a prior hostile relationship to be relevant to a defendant's motive to kill the victim, the evidence must actually establish a prior hostile and violent relationship between the victim and the defendant. And then they're citing some different case law here. Oh, wow. Look at that footnote. This case law is not comparable to this incident during which Miss Reed briefly became angry with another woman, not the decedent, because she believed that Mr. O'Keefe had kissed that woman. There was zero physical violence here. It's another good point, right? The fact that she was not angry with the decedent, right? There was zero physical violence here, nor no threats of violence, no police involvement necessary, and absolutely no history of violence in Miss Reed and Mr. O'Keefe's relationship. Moreover, even when this type of evidence might be relevant for some limited purpose, the evidence must be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant. And again, I have to feel like this would have been the same motion would have been made for the first trial, right? And again, the thing is we know it came in. So unless they're making some other new argument, probably going to come in, unfortunately. So then here's this footnote, section 404B. 404B. I love that. I love a good 404B analysis. Permits the court to exclude evidence of a crime, wrong, or other act that is offered for a proper purpose. So again, these are your exceptions where you can get it in. Motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. If the risk of unfair prejudice simply outweighs the probative value of the evidence. This is a more exacting standard than the standard set forth in section 403, excluding relevant evidence for prejudice, confusion, waste of time, or other reasons, which permits the court to exclude relevant evidence if the danger of unfair prejudice, confusing it's just listing all those again, outweighs the probative value. Again, prejudicial versus probative. Compare evidence code 403 with evidence code 404B. That is because bad act and propensity evidence is inherently prejudicial, and the risk of improper use is enormous. So let's think about this again. So they're saying there's a distinction here. 404B2 permits the court to exclude evidence of a crime, wrong, or other act that is offered for a proper purpose. So what they're saying is, okay, so in 404B, even if there is a proper purpose. So let me just back up. So in 403, right? You can have a proper purpose for it, right? And then it is what it is. And then you might be looking at, is it relevant? Is it confusing? Is it a waste of time? Right. However, with 404B, subsection 2, even if it does meet that standard for a proper purpose, it can still be excluded if it's still found to be more prejudicial than probative. That's what that's saying. Okay. And then indeed, Massachusetts courts have long held that where evidence of prior bad acts is relevant for purposes such as intent or motive, it should be excluded if its probative value is outweighed. There it is, by the risk of unfair prejudice to the defendant, even if not substantially outweighed by that risk. So even just a small amount, right? Here, testimony by Marietta Sullivan that Miss Reed became angry with Marietta, not the decedent, on December 31st, 2021, because she believed that Marietta had kissed her boyfriend, John O'Keefe, is simply not probative as to whether Miss Reed had an intent to murder John O'Keefe. Yeah, I mean, and that's the other thing, right? Because I don't even think the Commonwealth is trying to say this was premeditated, right? I mean, unless that's why they brought this in, but it's not charged that way. Like, it's not charged that way. Let me just refresh our memories, including my own, on what exactly it says it's second degree, right? So, let me just pull this up real quick, or maybe just read it to you guys. All right. So, and we've gone over this, in the first, during the first trial, right? We went over all of this with the elements of the charges. But let me just share this to you guys real quick, just to refresh our memories. Meg better not be asleep. Just kidding. Okay, so murder in the second degree. In order to prove murder in the second degree, Commonwealth must prove the following elements. 1, the defendant caused the death of the victim. 2, the defendant intended to kill, the victim's name, or intended to cause grievous bodily harm, or intended to do an act in which the circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood that death would result. So basically, the person got killed, and the defendant intended to kill them or harm them, right? So that's why, dude, Lolly, it's like, even if he wanted to be like, oh, it's premeditation, it's like, it's not, but also that's not even part of this, of the statute for second degree murder. So, oh God, maybe he thought that he could try to prove motive. The jury would just get confused and be like, yeah, it's, wait, hold on. That's not what I meant to do. Let me share the right thing. Okay. I mean, why the fuck do you guys think Lolly brought this in? I mean, and that's the thing, right? If it's not actually to prove any element of the charges, then really by default, it is in fact just to prove bad character, right? I wonder if they'll make that point. That's the point. That is the point. If it does not prove any element of the crimes as charged, which it doesn't, then really the literal only reason is because it's trying to show bad character, and therefore it should be excluded. This event was, okay, so not probative as to whether Miss Reed had intent to murder John O'Keefe. Okay. This event was remote in time and was clearly not an issue between O'Keefe and Miss Reed on the night in question, as evidenced by video surveillance footage from the waterfall bar and grill on the night in question and the testimony of 8 witnesses, all of whom agreed that the couple appeared happy and in good spirits. There is no logical relationship between the Aruba incident and the crime charged. The Commonwealth's attempt to characterize this misunderstanding as some sort of turning point in Miss Reed and Mr. O'Keefe's relationship is off base and unsupported by the evidence. The sole purpose, there it is. Okay, so they are making the argument. Excellent. The sole purpose of the Commonwealth's attempts to admit this evidence is to sully Miss Reed's character by allowing Marietta Sullivan to testify that Miss Reed sucks. If we are to believe the Commonwealth's best evidence, i.e. that Miss Reed said, "Go fuck yourself" to Marietta when she temporarily believed that she observed Marietta kissing her boyfriend on New Year's Eve in Aruba. Say it. I'm closing my eyes so I don't look ahead. I hope that they say what it, like, I know they're not going to say it, but like what they should imply is, what does that say about your case, right? This is your best evidence. So New Year's Eve in Aruba, that evidence is simply not probative of a motive to murder Mr. O'Keefe more than a month later when parties were, by all accounts, in good spirits. Yeah, and again, motive is not part of it, right? In order for there to be a logical relationship between the prior bad acts evidence and the crime charged as required by the Commonwealth, the jury would need to believe that Miss Reed reacted with a verbal "go fuck yourself" when she believed she had observed adulterous behavior on December 31st, 2021, but then subsequently flew into a murderous rage a month later when this event was remote in time and not the subject of any arguments on the night in question. That type of reasoning defies logic. Yes, well said. Miss Reed's short-lived anger was not even directed at Mr. O'Keefe, and her apologetic conduct after the incident demonstrates that she knew the kiss could have been a misunderstanding. The only reason for the admission of this evidence is to sully Miss Reed's character and prejudice the jury against her. Ms. Reed reasserts here that this evidence has no probative value regarding the crimes for which she's been indicted. Yes, absolutely. However, even if the court finds that this evidence is relevant, I almost said elephants, evidence is relevant, any marginal relevance of Ms. Reed's temporary belief that, and the reason that matters, right, is because the fact that it was temporary, that speaks again to the remoteness, I guess, in time, where, again, a month isn't maybe all that remote, but the fact that it was like a fleeting temporary misunderstanding could, I think, is actually more important than the month period. But anyway, temporary belief that O'Keefe kissed another woman 1 month prior might have in terms of evidencing a hostile relationship or intent to murder is far outweighed by the prejudicial inflammatory effect it will have on the jury. All right, the Commonwealth must be prohibited from calling witnesses to testify to inadmissible hearsay for the purpose of attempting to show a hostile relationship. Moreover, Massachusetts courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. The Commonwealth's argument is in prior proceedings that this testimony is admissible. Oh, good. I was curious, how the fuck did they get it in the first time? So they said it was to show the defendant's state of mind. Okay, so this is going to hearsay, right? And so state of mind being an exception to hearsay. But they're saying, so that's misguided. Again, the events in Aruba took place a month before John O'Keefe's death, and there's no evidence to suggest that Miss Reed was still upset about it on the night of January 28th, 2022. Right. So I will just make a distinction between state of mind and present sense impression. Right. So state of mind, again, that's different in the sense that it's not a present sense impression, as in this is what it seems like at the time. So for example, if there were witnesses that night at the bar that said, "Oh yeah, she was upset about Aruba, blah blah blah," then the Commonwealth could make this argument, and I would say it would be a good argument, right? That if she was still upset about Aruba, it would show her state of mind, right? But she wasn't, right? So in other words, maybe it was her state of mind at the time, but it's not her state of mind on the night in question, if that makes sense. Couldn't agree more, Candace. I was thinking the same thing. I think we need to consult Elaine about this data. Yep. Let's just, yes. And I literally was thinking that. Y'all who were here for all that craziness. Autocorrect is wild. I agree. So it's just, we got some Nightbot here. And there should be another one coming. There it is. There it is. The Commonwealth statement, or sorry, we already read that one. So it's misguided. Right. Again, the events in Aruba took place a month before John O'Keefe's death, and there's no evidence to suggest that Miss Reed was still upset about it. Right. Here, testimony by Laura Sullivan regarding the irrelevant and inherently prejudicial Aruba incident must be excluded because this witness has nothing to testify about other than inadmissible hearsay and prejudicial character evidence. Well said. Indeed, during the 2024 trial proceedings, the Commonwealth chose to put Laura Sullivan on the stand to testify about an incident that she did not witness. Yeah, it's crazy. In Aruba, on December 31st, involving Miss Reed, Mr. O'Keefe, and her sister, Laura Sullivan was also permitted to testify about her completely irrelevant negative impressions of Karen during the planning of the Aruba trip, i.e. that Karen told her she needed her own bathroom, that she didn't want to share a room with John's kids. The Commonwealth then elicited an additional inadmissible and prejudicial hearsay testimony from Laura, who told the jury that Mr. O'Keefe told her that Karen is crazy during a later conversation on the night of December 31st, and then on January 2nd, John insinuated that he was unhappy in their relationship. Footnote 2. Note, this unhappiness was allegedly communicated non-verbally. I forgot about that. Like that, this is insanity. It was communicated non-verbally. So like psychic, are we talking psychic abilities? And solely via Mr. O'Keefe's body language, namely a shrug and an eye roll. Oh my God, I forgot it was that bad. Not even body language people would be like, here's what that means, and it would mean something like what they're saying. Not only is this inadmissible hearsay, but it's an interpretation of a gesture, not an assertion of actual words that Mr. O'Keefe said to Laura, and thus calls for speculation. And even if it was words, it would still be hearsay. It's worse than that, though, because it wasn't even words. It's just, this is insane. Notably, Massachusetts courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would, oh, they already said that. They're repeating it. Okay. Thus, all of Laura Sullivan's testimony regarding the Aruba trip constitutes prejudicial and inadmissible hearsay, which must be excluded. Conclusion, don't let it in again. We'll see what she does. Oh my God, Judge Bev. I'm going to take a little quick break to appreciate some of these new clips we got here, courtesy of Mr. Alessi.
They don't even have evidence, let alone a preponderance of the evidence. Hard as a rock, freeze-thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
Lolly's head is as hard as a rock, I'll say. Okay, next up, defendant's motion to eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire. Okay, so given that these expert expenses, so this is the ARCA dudes, right? Given that these expert expenses were incurred based solely on the request of the Commonwealth and the mandate of the court, their inclusion in testimony would not be probative of any fact of consequence. Oh, okay. Okay. So what they're saying is this, that interesting. Well, I think we're going to learn more about this payment thing here, but basically what they're saying is that the voir dire, right? They had to pay them for their time for the voir dire, right? And the only reason they had to do that is because the Commonwealth wanted a voir dire, right? Well, and I guess Judge Bev to a certain extent, although that she can't say that, but you know, and so they're wanting that to be excluded. So what that would mean is whenever it comes out about the expenses, it would just be for like their testimony or whatever. Let's see what they say. That's interesting. In advance of both, I mean, to me, it's like, just get it all on the table, how much you paid them. But like, I would hope they handle it differently this round, right? With the third party that hired them and all that because of what happened with the jury last time. I'm sure we'll see something about that at some point. Because the thing that was supposed to make them the most credible, the previous jury used it against them. Just say they must be hired by Turtle Boy and whatnot, which is just insane. Factual background. In advance of both the first and second trial in this matter, the Commonwealth requested and the court ordered in-person voir dire for defense expert witnesses, including Daniel Wolf, Andrew Rentschler, and then Dr. Marie Russell. As a result, Ms. Reed had to expend significant resources to pay for out-of-state experts to travel to Norfolk Superior Court for voir dire hearings, which span multiple days. To the extent that the Commonwealth seeks to cross-examine these experts regarding any fees they've been paid to testify in connection with this case, the Commonwealth should be precluded from eliciting testimony regarding any fees. Now, here's the thing. In every trial, right, there's oftentimes voir dire witnesses. I don't think this is ever excluded. But okay, argument. Expenses incurred by Ms. Reed as a result of expert voir dire are irrelevant. The fees and expenses related to expert voir dire are entirely irrelevant to expert credibility and do not make any fact of consequence more or less probable. Discussion of the fact that an expert witness is compensated for their time is acceptable so that juries may assess expert credibility and bias. However, testimony about fees and expenses incurred as a result of voir dire have no bearing on an expert's credibility at trial. I mean, that's true. I just feel like, more often than not, there's voir dire of experts for trials, right? And I feel like that's just included. Now, they don't specify how much of this money was for voir dire and how much was for whatever, but it's just, they get paid. This is particularly the case here, where in-person voir dire was conducted at the request of the Commonwealth and where a significant portion of voir dire expenses came from travel and lodging. Well, having said that, though, I guess their lodging would have been extra nights, but like, in other words, their travel, though, they had to travel there anyway. It's not like they went home and came back, right? They did it on purpose so that it would be right before their testimony. So maybe lodging would be extra expenses. Discussion of fees and expenses incurred by the defense for expert voir dire would not provide the jury with any additional clarity about expert motivations or biases. The in-person voir dire of experts was conducted at the Commonwealth's request. Moreover, the defense would have no way of clarifying this issue on redirect without eliciting the fact that there was a voir dire hearing, which is information that the jury should not be privy to and would not understand. Which is exactly why, like I was saying, I think they just don't even mention it. Like in most trials, it's just like the fees are the fees, right? They don't make a distinction. Voir dire fees and expenses are separate from potentially relevant fees and expenses accrued at trial and therefore should be excluded. I mean, if that's the case, that should be the case in every trial, right? That seems like one of those things that's like, either you include voir dire or you don't. Okay, so discussion of expert voir dire expenses would be significantly more prejudicial than probative. Even if testimony regarding fees and travel expenses incurred for experts' testimony at voir dire hearing is deemed relevant, it would be far more prejudicial than probative. Evidence deemed relevant may be excluded for a variety of circumstances, including where probative value is outweighed by risk of unfair prejudice, confusing the issues, misleading the jury. Exclusion is appropriate where the prejudice created by the testimony is unfair and may cause the jury to base their decision on something other than the established propositions in this case. Further, on cross-examination, a party may ask a witness questions pertaining to potential bias. However, where the relevance of the proposed evidence is no more than marginal value to the party conducting the cross-examination, the judge has discretion to exclude the evidence. Discussion of expenses and fees for expert witnesses incurred as a result of the lengthy voir dire hearings would be highly prejudicial while lacking probative value. Expert fees and costs related to voir dire required by the court has no bearing on expert bias at trial. However, because these expenses were high, particularly whereas here at least one expert had to testify in 2 separate voir dire hearings, the jury may come away with negative assumptions and feelings towards Ms. Reed. They may make assumptions about her financial situation or believe that the costs and expenses are related to expert trial testimony. The jury could feel that the experts are hired guns based on these inflated numbers or come to judge Ms. Reed based on assumptions about her financial situation. Such emotional considerations may impermissibly cloud the judgment of the jury and can lead to decisions based on emotions. I don't know if I would call it emotions, but rather than the established propositions of the case. In fact, such explanation would only serve to further prejudice Ms. Reed and to confuse the jury. When expert voir dire is conducted out of the presence of the jury, this separation may be viewed as a tool to prevent bias towards or against the expert. While Richardson is specifically focused on whether a judge must qualify an expert as an expert in front of a jury, it illuminates important considerations about the expert qualification process that are useful in this context. Ultimately, disclosure of fees and expenses incurred for expert voir dire would create an inaccurate and improper image of Ms. Reed's financial situation, causing unfair prejudice and a serious risk that the jury make credibility determinations based on the fact that voir dire was conducted at all. Both results would be unfairly prejudicial, far outweighing any potential probative value, and therefore testimony about fees and expenses should be excluded. Now it's going to undermine the fairness. Again, this is kind of the same. Okay, conclusion. Okay, I don't know. We'll see. I don't know how far that's going to go. Okay, next up. Defendant's motion in limine to exclude certain witnesses before and after testimony. So to exclude certain witnesses from the courtroom before and after testimony at trial in this matter. So the Massachusetts Rules of Criminal Procedure states that upon his own motion or motion of either party, the judge may, prior to or during the examination of a witness, order any witness or witnesses other than the defendant to be excluded from the courtroom. Okay, order them to be excluded. The power of a judge, I already know who this is going to. Do you guys? Power of a judge to control the progress and within the limits of the adversary system, the shape of a trial, is universally held to include the broad discretionary power to sequester witnesses before, during, and after their testimony. Again, it's sad, right, that they're like trying to empower her. Like you have this, you can make this decision. Like it's up to you, discretionary power. But like because it's Judge Bev, I don't know that you want to keep reminding her of that, right? For her, because we all know. Okay. Ms. Reed specifically requests that the court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their testimony at trial. As this court likely recalls, after they testified, members of the McCabes or McAlberts proceeded to sit in the gallery with the O'Keefe family facing the jury sporadically throughout the remainder of the trial, including closing arguments. Following trial, a juror reported to Vanity Fair magazine that he or she felt it was utterly inappropriate that the McAlberts were able to stare down the jury from their position in the courtroom. One juror reported in Vanity Fair magazine that he or she felt intimidated by the presence of the McAlberts, calling their presence in the courtroom's small gallery facing the jury completely and utterly inappropriate. Noting that the McCabes, or McAlberts rather, were substantial focal points of the trial, the juror noted how unbelievable it was that the families were allowed in to stare the jury down. This was extraordinarily prejudicial to Miss Reed. The alleged third-party culprits, Brian Albert, again, all the McCabes, sat in the gallery during closing arguments directly facing the jury, which, according to at least one juror, was intimidating. As the jurors heard, oh, and there's a footnote here. Courts have recognized that when a witness or person stares down a jury, that can make jurors feel timid or fearful. As previously noted, an individual does not need to do actual harm in order for an act to be considered intimidation. As the jurors heard through testimony that McAlberts have deep connections and familial ties to multiple state police forces and local governments. In addition, Mr. O'Keefe, a Boston Police Department officer, was a part of this tight-knit law enforcement community. By sitting with the family of John O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one juror felt intimidated by what he or she perceived as the McAlberts staring the jury down. Here, the judge has broad discretion to order the sequestration of witnesses before or after their testimony at trial. A defendant has a constitutional right to a fair trial to be decided by an impartial jury free from intimidation and undue influence. Given that at least one juror reported feeling intimidated by the presence of certain witnesses towards the end of the trial, Ms. Reed respectfully requests that the court exercises broad discretion to issue a sequestration order excluding all the McAlberts and Brian Higgins from the courtroom before and after their witness testimony. I mean, again, I think this makes sense, but is she going to do it? Probably not, sadly. Okay, next up. So now we're going to get to the chalk, which is the exhibit, right? So defendant's motion in limine to present demonstrative exhibit based on Christina Hanley's testimony. Remember how they called those chalks, but they said it funny and no one knew what they were talking about? This chalk is necessary to clarify critical evidence and will aid the jury in understanding the testimony presented. So background, we know the background. Okay, so this is about the glass. All right, so Mr. O'Keefe is captured on video surveillance footage leaving the bar with a cocktail glass from the bar in his hand. The Commonwealth claims that this glass remained in his possession at the time he arrived at 34 Fairview. Wait. At the time he arrived at 34 Fairview and was broken. There we go. And was broken in the early morning of January 29, 2022 outside the Albert residence after being struck by the taillight. So he just held onto the glass the whole time is what they're saying. the Commonwealth. Over the course of several searches, law enforcement recovered numerous pieces of glass from the yard of 34 Fairview and the rear bumper of Miss Reed's vehicle. The source of the glass recovered from the bumper of Miss Reed's vehicle and the lawn is material and relevant to this case. At the first trial, Christina Hanley, a forensic scientist at the Massachusetts State Police Crime Lab, testified for the Commonwealth about the pieces of glass recovered from the crime scene in the bumper. This testimony lasted more than an hour and spanned 37 pages of trial transcript. Throughout her extensive testimony, Ms. Hanley discussed 16 distinct pieces of glass recovered from 34 Fairview and the bumper of Ms. Reed's vehicle. These 16 pieces of glass originated from 4 separate sources. Some pieces of glass came from the same source, meaning they were originally part of the same object. I remember this. Do you guys remember this? Shout out to Kid Smiths. Welcome. Miss Hanley's testimony is very intricate and difficult to follow without some sort of visual aid. Yeah, and we all said that at the time. We were like, we need a visual aid, literally. During trial, Miss Hanley herself frequently needed to refer to her notes and request that counsel repeat questions to keep various pieces of evidence she was discussing clear. To remedy this problem, the defense proposes the use of a demonstrative aid consisting of one chart spanning 1 page, containing representations of all recovered pieces of glass and graphics depicting which pieces came from which source of glass. The proposed chalk tracks directly. I don't know how Judge Bev could deny this one, honestly. I mean, this is a no-brainer. And honestly, the Commonwealth, if they think if they believe their own theory, right? The Commonwealth should be asking for this, right? This is a Commonwealth witness. They should be wanting this. They should want to aid the jury in understanding where the glass came from. The chalk starts by identifying 4 basic categories based on where the pieces were recovered from and who they were brought in by. Each group of pieces is called an item. Those items are item 3.2, the base of the cup recovered from the scene. Item 3.3, 5 pieces of glass taken from the bumper of Miss Reed's car. Item 7.12, 9 pieces of glass taken from the crime scene by Trooper Buchanan. Item 7 through 14, a single piece of glass taken from the scene by Trooper Proctor. Each smaller piece of glass within items 3.3 and 7.12 has an additional lettered label referencing the individual piece itself within the broader item. And then ABC, right, I remember that. Yeah, all the letters for the report. Okay, for each individual piece of glass, the chart includes a graphic next to the corresponding label based on which other pieces of glass the piece matched. The graphics in the columns next to each label correspond directly with Ms. Hanley's testimony, particularly the testimony on certain pages of the transcript. Each sublabel has a graphic next to it indicating what other piece of glass it matches. Through these graphics, the chalk summarizes Ms. Hanley's conclusions into a simple chart, which Ms. Hanley confirmed was an accurate representation of her testimony. Argument. To assist the jury in visualizing Ms. Hanley's granular and essential testimony, the defense proposes the attached demonstrative exhibit, or chalk, to aid the jury, which is attached here too. A demonstrative exhibit is something presented to the jury. Okay, we know what it is. Right, can come in many forms. Yes, very useful. We agree. And then this is just explaining why they are allowed. The proposed chalk is highly relevant. Ms. Hanley's testimony is clearly relevant, i.e., whether any of the glass on the bumper matches the cocktail glass at the scene, or is from some different unidentified source, and goes directly to whether the evidence, in this case, supports that Miss Reed struck John O'Keefe or the cocktail glass in question. The relationships between the other pieces of glass are critical to understand the scene. Therefore, the chalk, which summarizes Ms. Hanley's testimony about this glass, is also highly relevant, especially given that the chalk provides much needed clarity to an otherwise complicated issue. Without a chalk, the jury would never be able to see, would need to be able to either accurately record or memorize, the source of each piece of glass and each piece's relationship to all the other pieces in order to make sense of her testimony. And I remember this in the trial, and like literally we were trying to follow it, and like my takeaway was it was just like a wash, because I'm like, I have no idea, right? It was so boring and drawn out from Lolly, and it was like, there was nothing, you couldn't figure out what the purpose was, right? You needed an exhibit, and we said as much at the time. So like, it wasn't even clear what the takeaway was, right? Did you guys have the same, do you guys remember it the same way as that? I mean, I feel like we were all very confused when we were watching it. The complexity of this testimony is underscored by Ms. Hanley's frequent references to her notes and requests for counsel to repeat questions, particularly questions about the relationships between those pieces of glass. Of course, referencing notes and requesting the repetition of questions is permissible and even preferable to ensure that testimony is accurate. However, if a lab expert has trouble keeping track of the labels of evidence that she analyzed herself, surely the jury would have even more trouble making sense of this critical evidence, making the chalk not only relevant, but essential. And again, wouldn't the Commonwealth also want this? Okay, the chalk would not prejudice, speaking of which, the Commonwealth. Any prejudice that may be argued to stem from the chalk is far outweighed by its probative value. This chalk does not prejudice the Commonwealth in any way. Rather, the proposed chalk would be highly probative in relation to Miss Hanley's testimony, which would otherwise require jurors to memorize and differentiate the titles and sources of various pieces of glass, which closely resemble one another. And Kitsmith is saying, yep, I also remember being confused. Yeah, it was confusing. It is merely a depiction of which glass pieces match each other and a visual representation. Even if the court finds that there is some prejudicial tendency to the proposed chalk, it is far outweighed by the probative value. I don't know what the prejudicial tendency would be. I mean, it is what it is. The Supreme Judicial Court of Massachusetts has been liberal in allowing demonstrations in chalks, even where there is potential for extreme prejudice. Where the defendant was, okay, so here's another case murdering a 6-year-old. That's, we don't, okay. We don't need to learn about that, but what they're saying is this is not even as severe and not as prejudicial, but it's certainly probative. The proposed chalk directly mirrors Miss Hanley's testimony fairly and accurately. As described in detail above, and as seen in the chalk itself, the chalk is merely a summary of her testimony. 4 categories. Actually, okay, in fact, during the first trial, Miss Hanley was shown this exact chalk. Right, but she confirmed on the record it was an accurate reflection. I remember that. She was shown this, but then they couldn't do anything with it, which is insanity. Without the chalk, Miss Hanley's testimony will be exceptionally difficult for the jury to follow, which would seriously detract from the important evidence Miss Hanley will present. Given the great relevance of the contents of this chalk, its lack of prejudicial tendency, and the tight relationship between the chalk and Miss Hanley's testimony, the proposed chalk should be permitted. For the above reasons, we ask that they can present it. Okay, Commonwealth's motion. So now this is the first one of the batch that I was able to obtain so far. That is from the Commonwealth. Commonwealth's motion in limine to allow expert Cellebrite demonstration. Oh boy. The Commonwealth respectfully requests that during Mr. Whiffin's expert testimony, the court allow him to conduct a courtroom demonstration of how data is stored within Jennifer McCabe's cell phone. Mr. Whiffin, okay, we know who he is. We know what Cellebrite is. Also, Jessica Hyde will use a courtroom demonstration. So I don't think she used a demonstration last time. Of course, I think Ian Whiffin, he did, but I don't think that Jessica Hyde did. Although that was the one where the feed cut out, if you guys recall. So I don't know if we just missed it. Not just we, but everybody. And remember how also they had it. That was also the day where they had the camera in that really weird place. And so we maybe didn't see everything. But yeah, okay. So Jennifer McCabe provided her cell phone to law enforcement in the days following John O'Keefe's death. Cellebrite was used. Okay, we know what that is. In Mr. Whiffin's expert reports provided to the defendant in 2023 and 2024, Mr. Whiffin utilized his superior knowledge of Cellebrite software to demonstrate how, where, and when Jennifer McCabe's Google searches were stored within digital databases. That's hilarious, DSN. That's funny. The Commonwealth moves to permit Mr. Whiffin to conduct a demonstration using Cellebrite software to enable the jury to better understand the digital forensics. It is within the sound discretion of the trial judge to permit a courtroom experiment. Some case law there. The Commonwealth intends to have Mr. Whiffin use the highly disputed extraction report from Jen McCabe's cell phone, Jen, to demonstrate with Cellebrite software how, where, and when the digital data of the Google search was stored. This demonstration would closely mirror the actual searches conducted by Jen McCabe and would aid the jury in understanding how Mr. Whiffin is able to opine that the contested searches occurred at approximately 6:24 a.m. and not 2:27 a.m. Notably, the defendant does not dispute the reliability of the Cellebrite software, and her own expert has relied on Cellebrite to draw their conclusions. In addition, both Mr. Whiffin and Ms. Hyde would use demonstrations to articulate and explain important data information contained on both Jennifer McCabe's and John O'Keefe's phones. The use of a Cellebrite demonstration by the expert who is the senior digital examiner for Cellebrite would serve the essential truth-seeking function of the jury, and the demonstration would be relatively short, concise, and without unnecessary technical language as to not confuse the jury. That's it for that one. Okay, I think this is the last one that I have, but this one is maybe one of the most important ones in my opinion. I'm sure we are all going to be glad to see this. Defendant's motion in limine to allow counsel to state grounds for objections to promote judicial economy and efficiency and to adequately preserve issues. So here's the thing. Beyond even the appellate issues that this can cause, just going to throw this out here, right? We see this all the time in trials where somebody objects and then the court asks them for their grounds and they don't have one. In other words, they just object, but they didn't have an actual objection, right? They just say objection. And in times where they can't come up with something fast enough, it's overruled. Or they might state the grounds, and the grounds are not the right objection. We say this all when we're watching trials. How many times do we comment on that? All the time, right? I'm like, nope, that was the wrong objection. That was the wrong objection. That was the wrong objection, right? And then it gets overruled. Other times, the court will sometimes give them a chance to try again. The other thing that's crucial is that it allows for the other party to, or for the party who's being objected to make the case for why this objection should be overruled. So among the myriad reasons why I can't stand the fact that she wasn't allowing, objections, the legal grounds to be stated, the thing is this, that it allows for either party, right, to lodge an objection without actually having the objection in mind. And they should know what objection it is. That is the point. That's why you have to state it. And to the end that anybody, well, let me just read it, and then I've got an idea here, but let me see what they say. Okay. Allow both parties to briefly and concisely state grounds for their objections in open court during the retrial in this matter in the interest of promoting judicial economy, the efficient administration of justice, and the preservation of issues. Oh yeah. Right, Elaine? I know. Exactly. Yep. Because Elaine would do that. And that's exactly the thing. That's just one example, right? Where they actually don't have an actual objection. So, yeah. Okay, so then we have this footnote. So undersigned counsel would like to know that this is not a request for lengthy speaking objections. Any issues that could be perceived as having the ability to coach a witness while on the stand or potentially bias the jurors with extraneous information that will still be dealt with at sidebar. Counsel's merely requesting the ability to state grounds for their objections. By way of example, rather than simply stating objection, counsel would state objection hearsay or objection calls for speculation. Okay, so now is a good opportunity for me to say the thing I was going to say just a second ago. Because somebody like Judge Bev might still say, well, but the jury's going to learn what speculation and hearsay are, for example, right? And that it could be used to, because attorneys do this all the time. I've seen that. We've all seen this, right? Where they will lodge an objection, and it could be the appropriate objection, or it might not be, right? But the point being that even if it's not the right objection, the point is like they get to say objection, and then they say whatever the grounds are, and they hope that the jury hears it and that they start to figure out like, improper impeachment. Like maybe the jury doesn't know what impeachment is, but they hear improper, and then they're like, oh, the other side's being, whatever. You know what I mean? So may might be in this document, we will see, but one solution to that in case, because that's an argument. I mean, you have to remember who your audience is, and Judge Bev is likely to just deny all the defense motions, right? So one thing that I've seen done before is that when they give their legal objections, they actually state the rule. So for example, instead of saying objection hearsay, objection rule 803. That solves the whole thing, because now anyone who wants to make an argument that the jury is going to hear certain words that could be prejudicial towards one side or the other, or that, sometimes a legal objection, if you state the actual word, sometimes that can lead into a speaking objection. We see it all the time because attorneys just can't help themselves. If you limit it to the rule, it solves all of those issues. Like, I don't know why, like that needs to be the answer here. That needs to be in my opinion. I think that is the solution. Okay. As grounds for this motion, Ms. Reed states that the court's general order that counsel not state grounds for their respective objections before the jury led to extensive discussions at sidebar, which lengthened an already extensive jury trial. Ms. Reed further states that the inability of defense counsel to state grounds for objections could lead to their inability to preserve issues for any necessary appeal. Right. This is one of the reasons why this matters, right, for appellate purposes. Stating the basis for an objection in a word or two will not cause either side any prejudice. I'm so curious if they're going to suggest the idea that I had. It's not even my idea. I've seen it in trials. It's not often, but I've seen it. Stating the rule, as in the number, I would suggest it so that way you're giving her something that will be a lot harder to deny. Just saying. While Ms. Reed acknowledges that generally considerations of judicial economy must yield to the defendant's right to a fair trial, in this instance, it is the defendant making this request. Massachusetts courts and rules of criminal procedure have outlined several scenarios that demonstrate the general promotion of an interest in judicial economy and efficiency. Additionally, the Supreme Judicial Court has condoned the practice of taking motions for mistrial made during closing argument under advisement until the return of a jury verdict to promote judicial economy and efficiency to preserve valuable judicial resources by obviating the need for retrial should the jury. Interesting that they included that here, right? Wow. That's like a 2-for-1, a twofer. Let me read that part again. Additionally, the Supreme Judicial Court has condoned the practice of taking motions for mistrial made during closing argument under advisement until after the return of a jury verdict to promote judicial economy and efficiency to preserve valuable judicial resources, aka taxpayer dollars, by obviating the need for retrial should the jury return a verdict of acquittal. Finally, judicial economy was explicitly cited as a consideration by the Supreme Judicial Court in eliminating those so-called power of resurrection in criminal cases, noting, there are many rationales for the raise or waive rule. That is a necessary corollary of our adversary system in which issues are framed by the litigants and presented to a court. That fairness to all parties requires a litigant to advance his contentions at a time when there's an opportunity to respond to them. And that's one of the points I was making, right? The other party gets to respond or should be able to. And they can't with the way it works in the first trial. So respond to them factually if his opponent chooses to. Right. That the rule promotes efficient trial proceedings, that reversing for error not preserved permits the losing side to second guess its tactical decisions after they do not produce the desired result, and that there is something unseemly about telling a lower court it was wrong when it was never presented with the opportunity to be right. Yes. The principal rationale, however, is judicial economy. There are two components to judicial economy. One, if the losing side, as in losing to an objection, right, side can obtain an appellate reversal because okay, no, actually losing party. Okay, losing side. I guess this would be the same in civil cases where it's not always the Commonwealth, right? So if the losing side can obtain an appellate reversal because of error not objected to, the parties and public are put to the expense of retrial that could have been avoided had an objection been made. And two, if an issue had been raised in the trial court, it could have been resolved there and the parties and public would be spared the expense. Yeah, absolutely. Absolutely. Related to the now defunct power of resurrection doctrine, the failure of counsel to state grounds has, in at least one instance discovered by undersigned counsel, led to an appellate court holding that counsel had failed to preserve an issue. Yep. In an unpublished decision, oh, that's not the best then, but okay. Unpublished decision, the Appeals Court of Massachusetts outlined a scenario that could easily recur in this manner, absent the allowance of this motion in limine. The key passage from the opinion, unpublished opinion, reads as follows. The most hotly contested issue at trial was the identity of the shooter. The Commonwealth sought to establish the defendant's identity in part by introducing a security video of the shooting that showed the shooter wearing a white t-shirt and eliciting evidence that was what the defendant habitually wore. This evidence consisted of testimony to the effect that from a percipient witness, Erica Moody, a police officer, we don't need to, their names don't matter here, who was familiar with the defendant, and a police detective who had participated in the investigation and had viewed the defendant's social media pages. One of the officers here had authenticated 2 social media posts or photographs rather of the defendant wearing white t-shirts. This is crazy, right? A white t-shirt. The defendant argues on appeal this is inadmissible habit evidence. The parties dispute the standard of review with respect to the habit testimony. The defendant argues that the issue was preserved and that standard of review is for prejudicial error. The Commonwealth argues that it was not, and that the standard of review is for a substantial risk for a miscarriage or of a miscarriage of justice. We agree with the Commonwealth. The prosecutor twice asked Swan whether the defendant typically wore any particular type of clothing. Defense counsel objected to the first question without stating his grounds, and the judge sustained as to foundation. The prosecutor immediately laid a foundation and asked the question a second time. Defense counsel again objected without stating his grounds, and the judge overruled the objection. In these circumstances, it is clear that the overruled objection was based on foundation grounds, which is insufficient to preserve an objection on habit grounds. All of this to me just says that I can't stand this whole thing because it's the judge trying to read the mind and like not even, right? It's just gross. You don't know why they're objecting again. It could be different grounds. We see this all the time in trials. How many times? Objection, foundation. They lay the foundation. They go through it. Objection again. But usually it's a different objection, right? But apparently the judge just assumed it was, yeah. The overruled objection was based on foundation grounds. But they'll never know because it's not in the record because they couldn't state the grounds. While defense counsel objected at sidebar shortly before Dugan's testimony, the objection was only to the introduction of the photographs, not the testimony. Oh, and was on cumulative grounds, which is insufficient to preserve the issue for appeal. Okay, so the defense counsel fucked up there basically by not preserving the issue on that second objection. There was no objection at all to Moody's testimony. Okay. Put simply, defense counsel's failure to state the grounds for his objection led the appeals court to infer the grounds for his objection. Yup. And having done so, to determine that the defendant was entitled to a less deferential standard of review to which he would otherwise have been entitled had the correct issue been preserved. Although the court went on to say that even if the court had applied the more deferential prejudicial error standard, which it did not, the court would still have determined that the error did not influence the jury and had but very slight effect. More important than the specific facts in that case, however, is the fact that the appeals court agreed with the Commonwealth that because defense counsel had failed to adequately preserve the issue, because he failed to state the correct grounds for the objection, the standard of review on appeal would be less favorable to the defendant. Since the ability to state the grounds of objections will both, one, further the interest of the court and the public in judicial economy and the efficient interest of justice, two, will avoid the possibility of failure by counsel to have the ability to adequately preserve any possible issue for any necessary appeal, and three, would cause prejudice to neither party. Ms. Reed respectfully requests that counsel be allowed to state the grounds for objections during the retrial in this matter. And that is the last one that I have, guys. There's probably more out by now, but you can't just get them. It's not like that. So it's like a whole thing, as you guys may have heard. Right. Exactly. Kitsmits. Plus, this essentially allows a judge to coach the attorney on how to properly. Yep. Yeah. So, but I will say, now that we got to the end of the document, that one of the things that I was wondering about was, were they going to make that argument about just giving the rule number? And they didn't. So I think that would have been good to include. I really do. I really do. And the thing is this. Judge Bev's not going to suggest that, right? She would rather just flat out deny their motion than say, you know what, I'm denying it, denied in part and granted in part, right? With like, here's the thing I will allow. And then like, she's not going to do that. I would be shocked. I would be shocked. I would be shocked. And so I don't know. It's interesting. I don't know why they didn't include that as an option. So for anyone who hasn't heard, I've been working on getting things together for our first members only live stream, and it is well on its way, guys. What we're going to be doing is a trivia night with law related trivia. And, you know, this is a good way, I think, to start off our first members only live stream. And going forward, we can have other trivia nights on different things, or, you know, we've got other ideas that we've been talking about, but I thought this would be really fun. And so I am creating my own sort of way to do it where you guys can answer the questions and we can keep score, and it's going to be really fun. And I think that probably everybody will learn something too, because there's going to be questions that might be easier that most people know. You know, we're kind of running the gamut. There's some stuff that's more specific, more difficult questions, but there's also some questions that I'm pretty sure most people, if not everybody, would know. But either way, everybody will learn something and have fun. I'm sure of it. And yeah, the other thing too, guys, is I'm almost done. So some of you may have heard, I've been working on a thumbnail. So Lori Vallow, was it yesterday? I think had her hearing or a hearing, and she's pro se, as you guys may very well know. But what happened at this hearing is she had to argue exceptions to the hearsay rule to try to get in statements made by her brother who's deceased and her daughter who's deceased. And the judge was grilling her and she had to answer and exceptions to the hearsay rule. And she would like try to say one thing. He's like, nope, that doesn't apply. Next. And she had to, so it's really, I mean, I didn't watch all of it. I watched some of it, and it's not a long hearing, but it's really interesting. And so I've just been waiting to get that thumbnail finished so that we can watch it. So when is the next court date? The 17th for this case. And welcome, Tree. I don't recognize your name in the chat. So welcome if you're new, or if you're not new, welcome back. But you're new to the chat because I remember people. So welcome, welcome. So the next court date for this is, oh crap, I think it's the 17th. I think it's the 17th. I have it time-stamped at the previous hearings when they talk about scheduling. I think it's the 17th. It's either the 17th or the 18th. It might be the 18th. Let me look at a calendar here. And they have like 2 days, and then that's it. At this point, it's 20 days until trial, I believe. It's probably the 18th because that's a Tuesday, and they usually do Tuesday. So I remember Judge Bev saying, so it's probably the 18th. I remember her saying the 18th and then maybe the 19th if we need it. And that's for the argument over the motions in limine, which that scheduling at the end of that last hearing was insane, because that's when you realize she's flat out going to deny the motion to dismiss and or evidentiary hearing. Not going to happen. No way. I was shocked. We went back and watched the entire thing again after we got scheduling, because now it's like, well, now everything is different. Now her questions hit differently. So it's the 18th. And then she said they have a backup day, and that's it. So, and I'm going to count the days just to make sure. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Yep, 20 days. 20 days until trial. 20 days until trial. Incredible. Hi, Julie Frew. Welcome, welcome, welcome. So yeah, so thank you for that question. So, I mean, it's crazy, right? Trial is so close. And she's just, like I keep saying, Judge Bev is like April 1st or bust, right? It's like, that's what it is. So she's in my opinion, she's making these rulings just based on simply trying to get to trial. And anything that could delay that is not going to happen for her. That's my thought on it. So yeah, so I was just telling everybody about the members only live stream. Right. And so then we will do the Lori Vallow hearing. So we'll be able to do that today. We'll be able to do that hearing again. It's not long at all, but it is very interesting to see her try to argue exceptions to the hearsay rule. And we're also going to get an idea of things that may come in at trial, things that won't. And basically it's again, motions in limine happening in all these cases. It's motions in limine is what they were doing at the hearing. And then there's also some more documents coming out of Idaho. So basically the Lori hearing is a given, but as far as like live streams for the rest of the day, it's going to be sort of based around what time things post and all that, right? Because we should be seeing way more documents for this case and also for Idaho versus Koberger coming out as well. So yeah, so that's what's going on. Oh, Julie Frew must be starting from the beginning of the stream and saying they didn't pay attention to Aruba. Okay. That's what I thought. Thank you, Julie. Yeah, the Aruba was ridiculous. So Tree says, I'm new here. Love your channel so far. Been following this case. Glad. Well, welcome. Dude, the Squirrel Crew is the best. We're happy to have you. We're like a family here. Feel free to join the Discord as well. We have so much fun and everybody is super awesome. I love the Squirrel Crew more than life itself. So we're very happy to have you. And any of you guys who were here last summer for the trial, for the Karen Reed trial, feel free to share with the newcomers the difference that you guys all voiced in terms of watching that trial with the Squirrel Crew versus elsewhere. Feel free, because I know that you guys had some thoughts about that. But we will be doing it again. So yeah, and also for anyone who's new too, I have playlists for all the cases that I have covered, am covering. There's playlists as well. So everything is grouped that way too, if you want to check those out for other cases. And I do really, really detailed timestamps. So it makes it, whether it's something funny happens or whether it's an important date or an important whatever, right? I do really detailed timestamps for myself and you guys, because sometimes I need to go back and find something like, oh, what was it in that hearing? And it's like, I know I have it timestamped, so I really detailed timestamps. So that should make it easy too for anyone who wants to catch up on anything from any of the cases as well. So yeah. But we will be back tonight with at least one other stream, probably 2 more streams. Okay, so Kitsmits is weighing in. Thank you so much. So it says much more friendly here. And we promote friendly debate. No trolling allowed. Trolls are argued out. Right. And to that end, there's only been one so far. Shout out to Glenn. Thank you so much for that, for your input, Kitsmits. And since I said shout out to Glenn, hold on. Where is it? Here we go.
I have that skirt.
That's the troll. That's the legendary troll that we had the one time, Glenn. And I mean, no one else, I don't think, would have tolerated Glenn for 3 hours and 40 minutes, but we did. That's what makes this channel, and you guys especially, unique, because we tried. We tried. That's sad and heartbreaking. DSN says, I lost many trial watching friends on other forums. Yeah, I hate that. I really hate that. It's should not be that way, during the Karen Reed trial. Yeah. I mean, and that's the thing. That was my understanding. You guys know I stayed completely out of it and didn't have any plan to watch or cover the trial until I heard Unetti's opening statements. That's the reason, is because I was like, oh my God, the fighting and the toxicity and the divisiveness. It's a real, it's a shame. And there's other cases that seem to have a similar effect, maybe not quite to that same extent, but you know, it's a way that same way that people can get divisive about politics and other things. You know what I mean? Right. Glenn was the memorable one. Yeah. So there's been other people that very rarely, right, that have popped in that might be like trolls, or they could even be bots. I don't even know. But literally we just ignore them and they just go away. So it's like they say one or two things and then that's it. They go away because no one responds. So Glenn was different in that he stayed and interacted for 3 hours and 40 minutes. What was that lady's name? I don't know who you're talking about. If it was from Karen Reed, I wouldn't have even been there. This was somebody in the chat, I guess. Oh, somebody that blocked you. That's funny. Yeah. So, I wonder if STS, I'm wondering if they're even going to continue covering Koberger, because they were going to have me on as like a best guest, which I thought was insane anyway. But like, I was waiting to get a call from Joel. I didn't hear back, and I haven't seen any upcoming live streams regarding that. And I did hear there was one show recently where Joel said something like, we're going to be paring down our number of cases and go deep and not wide, basically. And he said something to the extent of like, they might just cover like, try to limit themselves to like 5 cases at a time or something. And it made me wonder if they decided not to cover that anymore. And if that could be what's going on. I don't know if any of you guys happen to know for a fact, but Andrew, welcome. Why doesn't the Commonwealth want the truth? If the FBI doesn't think Karen did it, why wouldn't they reach out and see what evidence they have? We don't need wins. We need the truth. Couldn't agree more. Absolutely. And that's the thing, is we are totally here for the truth. And that's why I really appreciate that everybody can come in with like an objectively and set the, emotions aside if we can, which we tend to be able to do, and that's the thing. And these trials are rough, right? I mean, the injustice of it all is tough. We were just talking about this last night, actually covering Idaho. It is hard, but the thing is that, 100%. It's at the end of the day, nobody wins in these cases, right? Because somebody died. It's always murder cases, right? With the exception of every now and again of civil suits that might be worth covering. But, yeah, it is. I just agree. I totally agree with what you said there. Thank you, Andrew, for that comment. Sarah, oh, I remember that person. I haven't seen her in a while, although I'm not always able to be in the chat because I'm usually on replay crew these days because I'm streaming. Yeah, I remember her. Yeah, I don't know if she's around anymore, but I remember her from back in the day for sure. That's funny. See, I appreciate Kit Smith always has an open mind. Frankly, I'm still open to the possibility that Karen is guilty. I think it's unlikely that I'd be convinced beyond a reasonable doubt it's a possibility. Yeah. I think for me, the thing that does it for me is like he wasn't hit by a car. It's like it ends there, right? It ends there. Like had the thing is like had the Commonwealth wanted to go a different route where she killed him, but it was by some other way, that would be different, right? But the Commonwealth's theory is she killed him and the car was the murder weapon. But he wasn't hit by a car. And that's the ARCA dudes. It was just not even, I mean, it seemed, it's like going along. It's like, it seemed like that couldn't possibly have happened, but like, I mean, I know I was staying open to it. Right. Or what, and then you had Trooper Paul and then you had the ARCA dudes and it's like, okay, yeah. So if he was not hit by a car, it doesn't matter if she killed him with a machete, right? That's not what the Commonwealth is. And not that I'm saying that obviously that's not what happened, but I mean, and my thought is I'm still a little bit suspicious about that fire hydrant, to be honest with you guys. Right. Couldn't agree more. It was a shit show. Absolutely a shit show. Yep. And that's a great point. That's why anyone who was too sure of themselves is out of line. Absolutely. Because of the fact that it was a horrible investigation, a complete and utter shit show from the get-go. Absolutely. Absolutely. And it's also because of that we may not ever know the truth of what actually happened. That's the thing. We may not know what actually happened, right? Excellent point. Thank you, DSN, for that point. Yep. When you've got a really thorough investigation, it's different because you can rely on the evidence. But here, there's either no evidence or the evidence is highly suspicious. And again, we can just quote Lolly back to himself, and then we can also quote Alessi.
There's no evidence of anything in this case.
They don't even have evidence, let alone a preponderance of the evidence.
Just for good measure.
Hard as a rock, freeze-thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
So yeah. Yeah, well, we'll see. I mean, yeah, if Judge Bev allows it, which looks like she will, she's allowing the dog dude. Yeah, they'll be entertaining, right? Right, agreed. Yep, he was, yeah. Yeah, and that's the other thing too, right? And especially, you know, we always talk about this too, like with the law, there's always gray area, right? And everything is always very subjective, right? And so, yeah, can't ever be 100% certain. I think that we could be 100% certain potentially, though, that Trooper Paul does not count as an actual expert anywhere. Like that's, if nothing else, it's like, if there's one thing I might be sure of in life, it's like Trooper Paul, Jesus. Right. Entertaining, especially if you let yourself forget that this shit is real. Absolutely. 100%. Yep. Yeah. When you remember it's real, then it's depressing. But if you just let that go, then you can laugh at it. And that's kind of, I think, how we get through how we got through it and how we'll get through it again. Right. The only thing is, like, it's shitty that, you know, we could laugh a lot at Lolly, but like with Brennan, it's more like he just pisses people off. Well, okay. He can, right? Because there's not as much to laugh at with him. You know what I mean? Like with Lolly, you know, I mean, my God, he was, you didn't have to make jokes. Like he did it himself. Like he, you know, and which he'll be there, right? He's just sitting there. He's just turned into a courtroom furniture, like a chair piece, courtroom furniture. So yeah, the crime's right. So yeah, Brennan, it's been interesting to watch him evolve over the course of the short period of time that he's been a special prosecutor for the Commonwealth, because he came in one way and it's very interesting. I've been commenting on it as the hearings go along. I always comment on it and I'm like, interesting. He's morphing. And I think I said it at one of the last hearing, like, if I were somebody in Massachusetts and I got charged with a crime, you know, and I was like following this case or I was watching him, I would not hire him as a defense attorney. Absolutely would not. Sure wouldn't. And it'll be interesting to see what happens after this, right? I mean, I don't know. Holly is a walking or sitting meme. Right. Yeah. Right. Brennan, he's just frustrating. Yep. Agreed. Oh, and that's going to be interesting. I don't know how they're going to handle that. We haven't heard him be brought up all that much in terms of what's going to happen this upcoming trial. We don't really know. I mean, what the fuck are they going to do with this? You know? I don't know how you get out ahead of that. It can't get any worse, you know? It like can't get any worse. If you're the Commonwealth and that's your lead detective, it just can't get any worse. They have not made I have not seen a motion in limine for that yet. Doesn't mean it's not coming, but I've not seen it yet. I don't think they can keep those out. You might be thinking about, there was talk about like his personal phone versus his work phone, but I think that was as it pertained to the board hearings and stuff, or maybe even like the federal investigation. I don't think that was related to this particular trial. I think it might have been one of the extraneous or adjacent proceedings. Because we cover every filing and every hearing and stuff with this case ever since the first trial, and there's not been anything about that I've seen or heard. Well, I guess they might have brought things up in hearings or referenced them, right? But not about keeping them out. That's not come up. But yeah, I mean, in other words, if they are going to have a motion in limine about it, we'll see it. It hasn't come out yet. It hasn't come out yet. So, so we'll find out. We'll find out shortly. No, it's all good. Yeah, again, it's tricky because there's the federal investigation and then there's also the disciplinary hearings that he's been having. And I think part of that might have been in relation to the disciplinary hearings. I remember hearing something about it as well, but what I can confirm is that there's not been anything on the record in terms of the filings or the hearings about the Commonwealth trying to keep those texts out for this trial, because we would have covered it. But could be, maybe, who knows, maybe today's the day, maybe who knows, like a couple hours from now could be, here it is, the, motion in limine about Proctor's text. I don't see how they could keep it out. There's just no way. So, but anyway, guys, we will stay on top of these things here as they happen. I appreciate all of you guys. I love y'all. Y'all are awesome. And I appreciate that, we can, I think, bring a good attitude to how to handle some of this stuff. And hopefully, hopefully people who are not happy with the climate, maybe they can find us as well. And we can be a safe space for even more people who are like, we don't like the fighting. And that's why the Squirrel Crew is the best. But other than that, I will see you guys soon, and squirrel out.